One interesting question is whether there could be litigation before domestic court citing the advisory opinion of international court. I think there has been some kind of movement towards that. Maybe if you are involved in any case like that, you can share some information with us. And also yesterday, there was a mention about the high-level meeting at UNGA next year as follow-up on advisory opinions. Are you involved in any way? Because
no.
Okay, now. Okay, we have the first panelist, Dr. Ximena HINRICHS. She is Registrar of the International Tribunal for the Road Sea. You have 15 minutes. Thank you.
Thank you. I wish first to express my sincere gratitude to the Ministry of Foreign Affairs of the Republic of Korea and the Korean Society of International Law for inviting me as discussant in this conference. Please note that I'm speaking in my private capacity. We have just heard three distinguished panelists deliver insightful presentations, and these presentations focused on maritime delimitation and climate change, two areas in which the judicial dialogue that has transpired between ICLOS and the ICJ has played a pivotal role. Judicial dialogue, we have heard, as a function of legal reasoning and normative integration, is indispensable for ensuring the essential consistency of international law. Clear examples of judicial dialogue, as has been shown, can be seen in the advisory opinion of the ICJ in relation to ICLOS. The practice of judicial dialogue between ICLOS and the ICJ is essential for understanding how judicial dialogue has contributed to achieving coherence. Firstly, this practice, as far as the law of the sea is concerned, has shown that courts and tribunals have followed a pattern of coordination and due regard for each other's jurisprudence, contributing to the establishment of a relatively coherent body of case law. Secondly, the practice has largely demonstrated that the anticipated fears of fragmentation that arose after the establishment of the tribunal in 1996 were unfounded. At the time, to avoid fragmentation, it was proposed to introduce a hierarchy among international courts and tribunals. With regard to this proposal, the then president of the ICJ, Judge Rosalind Higgins, stated in 2001, I quote, "I do not agree with the call of successive presidents made at the UN General Assembly for the ICJ to provide advisory opinions to other tribunals on points of international law. This seeks to reestablish the old order of things and ignores the very reasons that have occasioned the new decentralization," end of quote. That being said, there is fragmentation, conflicting findings have arisen in some instances, as occurred in the southern bluefin tuna cases. Thirdly, there has been some imbalance in the practice of judicial dialogue between ICLOS and the ICJ. Although not obliged to do so, the tribunal has referred extensively to the ICJ's case law, both in relation to the same subject matter and general issues of international law. Early in its decision, the tribunal relied on the jurisprudence of the PCIJ and the ICJ, for instance, on the issue of its competence to examine national law. And I refer here to the MV Saiga number 2 judgment, in which the tribunal quoted the PCIJ in German interest in Polish Upper Silesia, which appears to be the first judicial cross-reference by the tribunal. In the area advisory opinion, and I draw here from the presentation from Professor Barnes, the CBET disputes chamber cited several decisions of the ICJ in matters such as the status of the precautionary approach, the notions of an obligation of conduct and due diligence, and the scope of an environmental impact assessment. Now, in maritime delimitation matters, the Tribunal has cited extensively the jurisprudence of the ICJ on a number of issues, non-presumption of there being an agreement on the establishment of a permanent maritime boundary, the evidence of a tacit legal agreement, the effect to be given to an island, the establishment of base points, and low tide elevation. But the Tribunal's approach to the issue of the method of delimitation in the case between Bangladesh and Myanmar is particularly telling in terms of ensuring consistency in jurisprudence. On this issue, the Tribunal stated that, I quote, international courts and tribunals have developed a body of case law on maritime delimitation, which has reduced the elements of subjectivity and uncertainty in the determination of maritime boundaries and in the choice of methods employed to that end, end of quote. The Tribunal then referred to the decision rendered by the ICJ and Annex 7 arbitral tribunals, observing that, I quote, the jurisprudence has developed in favor of the equidistance relevant circumstances method. This is the method adopted by international courts and tribunals in the majority of the delimitation cases that have come before them, end of quote. However, it is also important to note that in examining the question of exercising its jurisdiction to delimit the continental shelf beyond 200 nautical miles in that particular case, the Tribunal followed a different approach. Noting the positions taken in decisions by international courts and tribunals on the matter, the Tribunal took a further step on the grounds that the exercise of jurisdiction to delimit the continental shelf beyond 200 nautical miles depends on the procedural and substantive circumstances of each case. On this basis, the Tribunal delimited for the first time in international adjudication the continental shelf between the parties beyond 200 nautical miles. This illustrates how courts or tribunals may address different judicial decisions and develop further the case law. And in this context, I would like to put a question to Professor Barnes. What options in terms of judicial technique would a court or tribunal have at its disposal if it disagrees with the decisions of another court or tribunal on the same subject matter? For various reasons, the ICJ appears to have been more hesitant in cross-referencing ITLOS jurisprudence. It has, however, referred to decisions of ITLOS in some of its maritime delimitation judgments. For instance, in the 2012 judgment in Nicaragua, Colombia, when considering Nicaragua's claim for delimitation of the continental shelf beyond 200 nautical miles. The ICJ highlighted that ITLOS did not determine the outer limits of the continental shelf beyond 200 nautical miles, but it extended the line of the single maritime boundary beyond the 200 nautical mile limit until it reached the area where the rights of third states may be affected. The ICJ emphasized that the tribunal's ruling on the delimitation of the continental shelf in accordance with Article 83 of UNCLOS does not preclude any recommendation by the CLCS as to the outer limits of the continental shelf, and that ITLOS further noted that a clear distinction existed between the delimitation of the outer continental shelf and the delineation of its outer limits. The ICJ has also relied on the tribunal's jurisprudence in the 2018 ICJ judgment between Costa Rica and Nicaragua and the 2021 judgment between Somalia and Kenya. Professor ELFERINK addressed the 2023 judgment between Nicaragua and Colombia and focused on the question of the interpretation of Articles 56 and 76 of the Convention and the relation between the regimes of the EEZ and the continental shelf. This question brings to mind Judge Ouda's dissenting opinion in the 1982 Tunisia-Libya judgment in relation to Article 56, paragraph 3. Judge Ouda stated, I quote, "Was it not, however, the intention of the authors of the draft convention that Article 56, paragraph 3 should be interpreted to mean that the regime of the exclusive economic zone will incorporate in principle the whole regime of the continental shelf?" End of quote. This question was addressed later in the 1985 ICJ judgment in Libya, Malta. The ICJ referred to the two institutions, the continental shelf and the exclusive economic zone, as linked together in modern law. In the Nicaragua, Colombia, it used the word interrelated. It seems to mean the same. The ICJ in Libya, Malta further stated that this does not mean that the concept of the continental shelf has been absorbed by that of the exclusive economic zone. It does, however, signify that greater importance must be attributed to elements such as distance from the coast, which are common to both concepts. Professor ELFERINK also referred to the Bay of Bengal cases and how the ICJ in its 2023 judgment considered that a gray area was of no assistance in answering the first question. It may be noted that at the time, a special chamber of the tribunal had rendered its judgment on the limitation between Mauritius and Maldives. In this case, one party, and this was mentioned by President Haida, had raised the issue of a gray area. However, the special chamber decided to draw a delimitation of the exclusive economic zone and continental shelf up to 200 nautical miles. It is worth recalling the special chamber's statement in this regard. I quote, Article 76 of the Convention embodies the concept of a single continental shelf. Neither party may claim or exercise sovereign rights or jurisdiction with respect to the exclusive economic zone or the continental shelf within the 200 nautical mile limit of the other party on the latter's side of the boundary. Therefore, the boundary has the effect of rendering moot the question of the limitation of the area of overlap between the claim of the Maldives to a continental shelf beyond 200 nautical miles and the claim of Mauritius to a 200 nautical mile zone. In an article by Professor Tanaka, he states that this would mean to give no effect to a continental shelf entitlement beyond 200 nautical miles and within the 200 nautical miles EEZ of another state. In this connection, I would like to ask Professor ELFERINK to share his views as to the relevance of the special chamber statement to the ICJ's approach in its judgment. In the particular context of the ICJ, I would like now to turn to the approach it adopted in its advisory opinion on climate change towards the ICLOS advisory opinion, which can be regarded as remarkable. As already indicated in this panel, in paragraph 338, the ICJ ascribed great weight to the interpretation adopted by the tribunal. We have also gained insight from the presentations into the various specific matters relating to UNCLOS on which the court followed the tribunal's jurisprudence. Allow me therefore to comment on a different aspect of the tribunal's advisory opinion, which concerned the relationship between UNCLOS and external rules. Its approach on the matter of integration of rules was crucial to achieving a consistent interpretation of the Convention and the external rules addressing climate change. The tribunal made clear that in order to identify the specific obligations under the Convention and to clarify their content, it had to interpret the Convention and in doing so also take into account external rules as appropriate. In this regard, the Tribunal emphasized the need for coordination and harmonization between the Convention and external rules, and noted that external rules inform the meaning of the provisions of the Convention. Using the term of Professor Barnes, tools for securing integration, perhaps I could mention here the three mechanisms through which a relationship between the provisions of Part 12 of the Convention and external rule is formed. One, rules of reference in Part 12 of the Convention. Second, Article 237 of the Convention. And three, Article 31, Paragraph 3C of the Vienna Convention on the Law of Treaties. So the Tribunal determined that relevant rules had to be found, and they were found in an extensive treaty regime addressing climate change. In this context, the Tribunal stressed the role of the Convention as a living instrument, an important statement which, in my view, points to the adaptability and openness of the Convention, enabling it to provide legal answers to new challenges, such as the impact of climate change on the marine environment, or to other emerging law of the sea related issues. I end with a question, perhaps to Professor AKHAVAN. He mentioned this idea of prospect in proceedings. Perhaps if he could further elaborate, taking into account the two advisory opinions, the prospect of litigation under Part 15 mechanisms and the possible role of ICLOS. And with this, I conclude my presentation and wish to thank you for your kind attention.
Thank you very much. Thank you, Nash. So we have the next panelist, Dr. LIAO Xuexia of Peking University. You have the floor.
Thank you, Judge KITTICHAISAREE. Good morning. It is my great pleasure and honor to be part of this distinguished panel. And I wish to express my sincere gratitude to the Korean Society of International Law, the Foreign Ministry of the Republic of Korea, and ICLOS for inviting me and giving me this opportunity to speak here at this distinguished forum, and for bringing us together for this timely and much needed discussion on the judiciary's role in settling maritime disputes and exploring new frontiers of international law of the sea. It is now commonplace to say that the international judiciary is multifunctional, as courts and tribunals are not only the instruments of states to settle their disputes, but also organs of the international regimes to promote the coherence of the legal order and manage issues of global concern. And I think this multifunctionality is clearly reflected in the topics covered by our panel. And I think a common theme of this panel is how we understand the role of international courts and tribunals as a critical force in the development of international law. In the following, I would like to focus on the implications of the ICJ's 2023 Nicaragua versus Colombia judgment for the law of maritime delimitation. In doing so, I will engage with the questions raised by Professor OUDE ELFERINK in his final slide, namely whether the ICJ's 2023 judgment signals a fragmentation of the international jurisprudence and whether it is likely to be the final word on this matter. On the first question, despite the discomfort with the problem of fragmentation, I'm afraid that I have to say straightforwardly that yes, I agree with Professor OUDE ELFERINK that the ICJ's reasoning on Articles 56 and 76 of UNCLOS is not persuasive. And I'd like to develop further why the court's reasoning can hardly be reconciled with the existing jurisprudence. As demonstrated by Professor OUDE ELFERINK, the relationship between the EEZ and the continental shelf, as understood by the ICJ, was critical for the ICJ to reach its decision. And in this connection, the paragraph from the Libya-Malta case was clearly a crucial link in the court's reasoning. Even though the court referred to it without further comment, But I think we have to contextualize its use by reference to Colombia's arguments, because Colombia constantly referred to the paragraph from the Libya-Malta case and argued that within the 200 nautical miles limits, the exclusive economic zone and the continental shelf are inseparable. And if the seabed and the subsoil of a coastal state was taken away from its EEZ, it would not be an EEZ anymore. I think the ICJ has seemed to accept this argument, and that's why the court emphasized on the interrelated relationship between the two regimes. So the first implication of the 2023 Nicaragua versus Colombia judgment is that within the 200 nautical miles limits of a coastal state, the continental shelf is in fact absorbed into the EEZ. This is a natural consequence of the court's understanding of the EEZ as a unitary regime. As the court's decision suggests that when the seabed and the subsoil forms part of the EEZ of one state, it cannot overlap with the seabed and the subsoil of another country's continental shelf beyond 200 nautical miles. However, this understanding of the relationship between the EEZ and the continental shelf disrupts the unity of the continental shelf regime. And I think it comes into direct tension with the established jurisprudence of unclosed tribunals that upholds the concept of single continental shelf. Unclosed tribunals have maintained the concept of single continental shelf in a number of cases, and its basic meaning is that the legal nature of the continental shelf remains the same within and beyond 200 nautical miles, and the coastal state exercises exclusive sovereign rights over the continental shelf in its entirety. Therefore, to say that one state's continental shelf beyond 200 nautical miles cannot overlap with another state's continental shelf within 200 nautical miles because the latter was part of the EEZ is for me to deny the unity of the continental shelf regime. And the second implication, which is closely related to the first one, is that the creation of gray areas would be impossible in the delimitation beyond 200 nautical miles, because it may be argued, given the ICJ's decision, that a continental shelf claim beyond 200 nautical miles should be found inadmissible as long as it extends into another state's EEZ, because, after all, the EEZ prevails over the continental shelf. This tends to be the minority view of Mr. P.S. Rao in Bangladesh versus India case, but unclosed tribunals did not subscribe to this view, and when they proceeded to the delimitation of the continental shelf beyond 200 nautical miles in the Bay of Bengal cases, they did not consider that the creation of gray areas incompatible with the relationship between the EEZ and the continental shelf, nor did they avoid its creation at the cost of an overall equitable solution. As pointed out by Professor ELFERINK, it is not convincing to set aside the relevance of unclosed tribunals' practice on gray areas by suggesting that it was an incidental result of delimitation. And this point was also made by Judge Tomka, who said that the decisions regarding the gray areas were premised on the existence of overlapping continental shelf entitlements. So either it is possible to have gray areas or it is impossible in all circumstances. So I think it is likely that the 2023 Nicaragua versus Colombia judgment will introduce a degree of uncertainty into the delimitation of the continental shelf beyond 200 nautical miles with regard to the question of gray area. And Professor ELFERINK also asked whether the ICJ's decision, namely that a state's continental shelf beyond 200 nautical miles may be limited by another state's 200 nautical miles limits, would be the final word on the matter. And I think one way to approach this question is to consider the potential impact of the 2023 judgment on the work of the Commission on the limits of the continental shelf. Specifically, should the Commission now regard the 200 nautical miles limits of other states as an additional constraint on the outer limits of the continental shelf beyond those already set out in Article 76, paragraph 5 and 6 of UNCLOS? I noticed that several authors have already advanced this view, and if that were the case, it would mean that the Commission should not recommend any area of continental shelf beyond 200 nautical miles that extends into another state's 200 nautical miles limits. However, I am not entirely convinced by this reading of the 2023 Nicaragua versus Colombia judgment. Firstly, I think the ICJ decided the case by formulating the problem as one and formulated the question as one of identifying customary international law. According to the structure of the 2023 judgment, the customary rule identified by the court was partly deduced by the court's understanding of the relationship between the EEZ and the continental shelf on the one hand, and the continental shelf beyond 200 nautical miles on the other hand. And this reasoning was also partly based on an inductive approach to state practice and opinion juries. Therefore, that the rule that one state's continental shelf beyond 200 nautical miles cannot extend into another state's 200 nautical miles is a separate rule from that of Article 76. There is thus room to argue that the ICJ's findings in the 2023 judgment do not fall within the legal framework that governs the mandate of the Commission, because according to Article 3 of Annex 2 to UNCLOS, the Commission makes recommendations in accordance with Article 76 and the Statement of Understanding. And to the extent that the ICJ's decision does not concern the interpretation of Article 76, I cannot see how the findings may inform the work of the Commission in respect of the delineation procedure. And secondly, I don't think the Commission is well equipped to take into account the 200 nautical miles limits of another state in the delineation procedure, because determining the location of the 200 nautical mile limits of other states is not simply a technical matter, but may involve the legal controversies. For one thing, the 200 nautical miles limits are measured from the baseline of a coastal state, and it may well happen that the states have have a different view regarding the validity of the baselines. It may also happen that the 200 nautical miles limits are measured from the coast baselines of maritime future, and according to the ICJ's decision that a state's continental shelf beyond 200 nautical miles cannot encroach upon the 200 nautical miles of an island. But again, in this scenario, it may happen that what about the status of that maritime future was controversial. So in both scenarios, the Commission does not have the competence to determine the validity of the baselines or the status of the maritime futures, and consequently, it cannot determine the validity of the 200 nautical miles of the other states. Given these practical difficulties, I think it is hard for the 200 nautical miles limits to operate as a constraint line in the work of the Commission. And as to other international judicial bodies, will the 2023 Nicaragua versus Colombia judgment signal a turning point in the international jurisprudence concerning the continental shelf beyond 200 nautical miles? As I mentioned earlier, the ICJ's understanding of the nature of continental shelf rights, the relationship between the EEZ and the continental shelf, and the gray area issue stands in tension with the jurisprudence of the UNCLOS tribunals. And I think this leads us to consider the respective roles of the ICJ and UNCLOS tribunals in developing the law of maritime delimitation. And before I continue, may I ask the assistant to kindly to turn the slide to the next page. Thank you. So I think there's no doubt that ICJ has been a primary force in developing the law of maritime delimitation. And a survey of the number of maritime delimitation cases submitted to international courts and tribunals, as shown on this page, demonstrate that the ICJ has adjudicated more maritime boundary cases than the combined total of those decided by the ad hoc arbitral tribunals and UNCLOS tribunals. UNCLOS tribunals only became significant actors in settling maritime boundary disputes in the latter half of the 2000s. Yet they were pioneers in developing the law concerning the continental shelf beyond 200 nautical miles, as 5 out of the 8 maritime boundary cases submitted to UNCLOS tribunals concern this question. I think their contribution lies in systematically theorizing the jurisdictional and admissibility issues in the delimitation beyond 200 nautical miles, and in developing the delimitation methodology applicable in the areas beyond 200 nautical miles. And they have now dealt with more cases concerning the continental shelf beyond 200 nautical miles than the ICJ, and have produced a relatively stable and consistent line of jurisprudence. In contrast, the ICJ's practice in this area has been marked by greater judicial hesitation. While the court has aligned itself with approaches of UNCLOS tribunals in many aspects, the 2023 Nicaragua versus Colombia judgment suggests that its reference to UNCLOS tribunals' jurisprudence can be selective. And I think this brings us back to the question of the importance of the judicial dialogue between the different judicial bodies. And I think given the asymmetry between the ICJ and UNCLOS tribunals in their approaches to the delimitation of the continental shelf beyond 200 nautical miles, it seems not unlikely that the UNCLOS tribunals will continue to follow their own established jurisprudence than following the 2023 Nicaragua versus Colombia judgment. Of course, whether the ICJ and UNCLOS tribunals will eventually move towards a reconciliation on these points remains to be seen, and I think much may depend on which forum the next case concerning the continental shelf beyond 200 nautical miles is brought before. And I could only hope that the future judicial and arbitral practice will enhance the coherence of the law maritime delimitation and help reduce the uncertainties that have persisted so far. I will stop here. Thank you very much.
Thank you very much for your presentations. Next, we have also Byung-Chun of Ajou University. You have 15 minutes. Thank you.
Thank you. I'm really happy to be here. I thoroughly enjoy our 3 presentations in this session 3. The first presentation gave my colleagues in the international legal affairs, including Ju, very insightful implication for the extension of the continental shelf agreement between Korea and Japan. I also totally agree with that Professor Richard Bruns, that the ILC has made significant contribution to the legal dialogue between the ICJ and ICLS advisory opinion regarding the climate change. Moreover, the Professor Payam AKHAVAN had a very wonderful presentation. I thought I should have brought my students in here. It's more than my class. I think this is a wonderful presentation. As I am studying and working on the field of international environmental law, I would like to discuss sharing my personal view on the advisory opinion on climate change and asking questions of our 2 speakers regarding the climate change. That is as the Judge Yusuf mentioned in his dissenting opinion, the ICJ exclude the issue of the 2006 draft principle on the allocation of loss from transboundary harm arising out of hazardous activities in the second question, scope of the legal consequence. That is my question. How do you think about it? Before I got into the discussion, I would like to share briefly my thought and memories on the International Conference of the Law of Sea as a member of the Korean Society of International Law. As I recall, prior to the first ICLS in 2016, the Korean Society of International Law and the Korean Minister of Foreign Affairs had participated in the Jeju Peace Forum, which is one of the big dialogue forum for the peace in Korean Peninsula, not only Korean Peninsula, but also East Asia and all over the world. We were engaging in the discussion on the various international legal topics, including peace, human rights, and the environment. In 2016, we held our first ICLS At that time, there were concerns about the sustainability of the international conference, solely focused on the law of the sea. However, 10 years later, the ICLS has attracted more than 200 experts, including judges of the ICLS and international distinguished scholars, and has established itself as a leading international conference specializing in the field. I believe it will continue to serve as an annual meeting for international lawyers for the next decades and beyond. I would like to express my gratitude to the Minister of Foreign Affairs of Republic of Korea for their continued support for the ICLS and to the ICLS for their active participation. I would like to also express my sincere gratitude the Professor Byung-Do Park, President of the KSIL, and the Seo Young-min, who organized this plan and planned the 10th CLS. Let me start the discussion with this question. How would you like to define the 21st century? The answer to this question depends on each of your position and situation. However, as a human being who are part of the ecosystem living on Earth, and in considering the impact of weather and climate on your daily life, the climate change, and more broadly, the climate crisis, are one of the keywords defining the 21st century. In 2025, a quarter of the 21st century has passed. The ICLS and ICJ has provided a legal opinion with significant implication for climate change to the international community. As you know, this year, ICJ advisory opinion regarding the two questions. First one is, what are the obligations of the states under the international law regarding climate change? And second question is, what are the legal consequences under not breaching this obligation for states? So I'm happy about the opinion of the ICJ in the first question, but I'm little not happy. I have some regrets on the second question, so I will focus on the second question. Before I go to the second question, so I totally agree with Professor AKHAVAN. The ICJ gave very significant meaning in the treaty obligation regarding Paris Agreement. First, the previous interpretation that setting the NDC, which correspond to national greenhouse gas reduction target, is left to the discretion of the individual country as long as it complies with the principle of clarity and transparency in Article 4 Paris Agreement. This is totally reinterpreted to include new interpretation that although NDC themselves vary depending on each country's circumstance, they must be set at a level that least enables and aligns with the agreement's objective. The second, in addition to the previous interpretation, there is no national obligation to achieve NDC per se. The court confirmed that the due diligence, one of the key words in this opinion, must be exercised in achieving NDC, and that violation of this obligation may result state responsibility. Due diligence is kind of duty of the conduct that requires taking all necessary measures to fulfill a specific obligation, regardless of whether the obligation is ultimately fulfilled or not. For example, even if both country A and B fail to achieve their NDC, if country A took all the necessary measures, it could achieve its NDC, given its own circumstance, and country B did not. Then country B may be in a breach of international law because she did not exercise due diligence, unlike country A, which is exercise due diligence. I think ICJ, in the regard of customary international law, also proposed the duty of the international cooperation and duty of the prevent significant harm to the environment of other country, so-called no harms rule. Both obligations actually are familiar with our international lawyers, having recognized as customary international law through the previous International Court of Justice cases and ICLS cases, and also state practice. However, ICJ clarified with the no harm rule as the obligation of state to prevent significant harm to environment by exercising due diligence, including by utilizing all necessary and available means, so that activity within their jurisdiction or control do not cause significant harm to the climate system and or environment in other country. I think due diligence is one of the key words in this opinion. By presenting no harm rule as an inherent duty of due diligence, the ICJ broke attempt by some states to weaken its effectiveness by separating two obligations. Citing existing cases, the ICJ cites an example of the environmental impact assessment, EIA, such as climate risk assessment, and notifying neighboring states of assessment results when the results said it might cause significant harm to them, as well as good faith consultation to prevent harm. In the second question, the ICJ ruled that no harm rule conforms customary international law and treaty obligation under the Paris Agreement are erroneous, based on the grounds that they protect the essential interest of all states in protecting climate system, which is the inherent interest of the all international community as a whole. However, as I mentioned before, it is a little regrettable that the ICJ limited the legal consequence of the second question to the legal consequence of breach of duty. In other words, the legal consequence following a wrongful act. And it applies only to the law of state responsibility of the internationally wrongful act. For example, 2001 ILC, the legal draft. As well-known, international environmental law encompasses not only wrongful act, but also obligation to prevent transboundary harm caused by non-wrongful, but hazardous activities, as well as liability norm for compensating for damage resulting from such activity. Representative norms include the ILC 2001 draft article on prevention on transboundary harm from hazardous activities and 2006 draft principle. It's not the draft article, but a draft principle on the allocation of loss from transboundary harm arising out of hazardous activity. In 2001 draft prevention regulation, key obligation include the no harm rule. And the 2006 draft principle of loss allocation, key content is prompt and appropriate compensation for damage that occur despite compliance with the no harm rule. According to the 2006 draft principle, specific compensation provision includes, first, the state assume institutional responsibility to ensure financial safeguard, such as climate insurance or industry-level funds, are in place to ensure adequate compensation for individual or industry that cause losses. This is also related to the discussion of a lot of climate change related fund within the loss and damage under the Framework Convention of the Climate Change Convention. In summary, in international environmental law, a state responsibility for climate change generally fall under no harm rule, failure to exercise due diligence in implementation, the rule of constitute a violation of law, resulting in the legal consequence. Even if there is no violation of the law, if the violation caused significant damage to the climate system or other environmental system, the compensation for the damage is provided through the fund as proposed in the 2006 draft principle on loss allocation. However, as my understanding, ICJ, the decision to limit the scope of inquiry to violation without providing an in-depth opinion on the latter issue in the consider. I think this is some said about that, and if I may, I would like to say it's a kind of abuse of discretion. This instance, I think this stance of the ICJ was also criticized by one of these judges, the Judge Yusuf from Somalia, in a dissenting opinion. He expressed regret, stating that contrary to the expectation that the ICJ would provide more concrete and substantive answer to the question, it instead engaged an abstract and formal review based on established law of state responsibility. And he added, considering the legal consequence of state action or omission in the climate change area, the complementary law of state liability system for damage resulting from acts not prohibited under the international law should have been recognized in certain circumstances. All of the ICJ cases requested, okay, I don't have enough time, so let me wrap up the discussion. A quarter of century later, we face the hottest and harshest summer of the year and year. We'll repeat this one yearly. Believe this summer might be the least hot. I think we need to do something all like action, all necessary measure, which is kind of due diligence. Perhaps our next generation, our descendants in the 22nd century will evaluate whether we have exercised the due diligence required by the 2024 ICLS and 2025 ICJ advisory opinion in climate change in establishing and implementing climate change policy. Thank you so much.
Thank you so much for exercising due diligence to keep within the time limits. So the last panelist we have, Mr. Eran STHOEGER of Columbia University. You have up to 15 minutes. Thank you.
Thank you, Judge, and thank you for the organizers, all of the organizers for inviting me and for the generous hospitality. Speaking seventh on a panel, you're always afraid you would have nothing left to say, but I find myself in a position where I have so much to say, but I promise to keep it to 15 minutes. Without disagreeing with anything said by Professor Barnes and Ximena, I do want to talk a bit about fragmentation to highlight a different point. We tend to think of fragmentation in the jurisprudence as negative. But I think it's important to note that in the words of the great George Gershwin in his opera Porgy and Bess, it ain't necessarily so. While legal systems should thrive, of course, for coherence and systemic integration, and states in the international legal system need to understand what their obligations are, sometimes getting the law right will necessitate courts to disagree with existing jurisprudence. Or in other words, dialogue or taking into account other jurisprudence does not necessarily end in agreement. And it's important to remember in this context that, yes, the ICJ did express its appreciation for the competence of ICLS when it comes to the law of the sea, and it did the same with respect to pronouncements of the Human Rights Committee in the Diallo case, as mentioned by Professor Barnes. But that did not keep the ICJ from disagreeing and disregarding, really, the committee under the Convention on the Elimination of Racial Discrimination, or the third committee, on the question of whether discrimination based on current nationality falls under the scope of the convention in Qatar v. UAE, without expressing the view on who got it right. And it may very well be that if a question adjudicated by the ICJ came before ICLS, and there are various subtle ways to do this, and Ximena spoke a bit about the jurisprudence, ICLS should not feel obliged to agree with the ICJ if it reaches the conclusion that the court got it wrong, even if it leads to apparent fragmentation. If my son were here, I would say that fragmentation may start with an F, but it's not the F word. So I think we don't have to be so afraid of it. Now this brings me to comment on Professor ELFERINK's presentation on the ICJ's judgment in Nicaragua v. Colombia. And here I should mention that along with Sir Michael and others, I also was counsel for Colombia. And so unsurprisingly, I disagree with Professor ELFERINK and Professor LIAO and agree with the court. Before getting into that, I would like to talk more generally about whether the ICJ's judgment will be the final word on the matter. And I think, well, of course, between Colombia and Nicaragua, it's a binding judgment, and it is the final word on the matter. But in a more broader sense, on the rule under customary law and under UNCLOS, in practice, many times the judgments of the court becomes accepted as law. And if you open EJL Talk this morning, you'll see a legal advisor and diplomat from an eminent Asian state saying that about sea level rise, that now that the ICJ has pronounced itself, there's no longer any room for any cogent argument that disagrees with the ICJ. So I think that disregards that in principle, of course, the ICJ or any court is only a subsidiary means of determining international law. And so whether or not any judgment is accepted is a matter for, first and foremost, states to determine in their reaction, and potentially other courts if the case or a similar case comes before them, be it ICLS or other tribunal. They may accept it, they may reject it, there may be nuances, and so on. And there have been instances where states have decided not to follow the court's jurisprudence. And just to give a couple of examples, the view taken by a substantial amount of states that there is a right of self-defense against non-state actors as opposed to the jurisprudence of the court. Or if we go back to the PCIJ in the Lotus case, states ultimately did not accept its jurisprudence on flag state jurisdiction. And this goes, in my mind, to a wider point about the international legal system. A healthy legal community must include critical analysis of the jurisprudence, be it the ICJ, ICLS, and this is even of the most highly regarded court within that system. And this is true within domestic systems of Supreme Court judgments. They should be analyzed and critiqued in a healthy legal discussion. And this is true of international jurisprudence as well. That said, coming back to the Nicaragua-Colombia case, I do think it will be the final word, not because the ICJ said so, but because it does correlate to the practice of the vast majority of states. And so that, I think, is more critical. Speaking to the judgment itself, I want to talk about one point of law and then one practical issue or difficulty that the court was faced with. And yes, I agree, Libya, Malta is, I think, relevant, but not exactly the same. There are, of course, gray zones in the jurisprudence and some in practice. And of course, I also agree that the court's reasoning is somewhat lacking in the judgment. All that said, so first of all, I would say that the way the court approached Article 76, giving less credence to the text itself, which I agree does not necessarily prioritize between the two shelves, but rather going more into the ordinary, into the object and purpose in context, I think is also reflective of its wider approach to international law in its recent jurisprudence. And if you look, it had a similar approach, I would say, in the recent UNRWA advisory opinion when it approached obligations under the UN Charter, when it approached climate change obligations in its advisory opinion, and also, I would say, when it approached GA resolutions in Chagos. And I think, so this is more reflective of a general approach. But again, back to this case, first of all, I don't think the court necessarily rejected the idea that there are competing entitlements between a distance-based shelf and an extended shelf. Rather, I think, and here I refer to a different special chamber, that in Ghana, Cote d'Ivoire, that I think it was more a matter of priority between entitlements or potential entitlements. And in this case, I think that it doesn't necessarily mean that there is no extended shelf entitlement. Of course, the result is ultimately the same. Now, I think even though the ICJ mentions this in passing in paragraph 78, I think more attention should have been given to the fact that this was not, and this was mentioned, not just a delimitation between continental shelves under Article 76, but also between an EEZ in continental shelf and an extended shelf under Article 56. And here, I disagree with the interpretation of Article 56 offered by Professor ELFERINK and Professor LIAO. I think Article 56.3 says that the rights set out in this article with respect to the seabed and subsoil shall be exercised in accordance with Part 6, the part about the shelf. And Professor ELFERINK reads this to say that these rights are then separated from the relation with rights in the water column. But if you look at the language of the article, it talks about how the rights are exercised. There is nothing about separating the regimes from each other. And to the contrary, Article 56 speaks of rights set out in this article, the article that is in Part 5 on the EEZ. And these rights may be exercised in accordance with Part 6, but they are rights under Part 5 on the EEZ still. And I do think that even though there were cases where a gray zone was created, there is a difference between when a gray zone is a consequence of delimitation and in the case of the arguments of Nicaragua, where a gray zone or a differentiation between EEZ rights and continental shelf rights are the actual rationale for a delimitation. And I do think these are different situations. As to a practical issue, and I'll skip a little, yesterday Judge Haydar spoke about the significant uncertainty test in Mauritius, Maldives, and others. So with respect to the entitlement to an extended shelf, if there is significant uncertainty, the court cannot proceed with delimitation of the extended shelf. Now, this was a problem in Mauritius, Maldives, and it wasn't a problem in the Bay of Bengal cases and also in Somalia v. Kenya. But those were cases with adjacent coasts, where the court could set a line with an arrow and it didn't need to determine the outer limits or the foot of the slope points. So in the case of opposing coasts or opposite coasts, even if you pass the significant uncertainty test, there's still a matter of determining the outer limit of the extended shelf, and it is necessary because without it, we do not know where the overlapping claims are. And so, faced with such a situation, I think there are really three options for the court. It could proceed to delineate the outer limits of the shelf in order to determine the area of overlapping entitlements, but I think UNCLOS Article 76 is very clear that that is within the mandate of the CLCS and not a court and tribunal. The second option is to delimit the areas of overlapping entitlements or claimed overlapping entitlements conditionally, or, but not permanently. And then this would result in the fact that later on, if the CLCS makes recommendations placing the outer limits of the shelf somewhere else, you would have to perhaps go back to the court or negotiate a different boundary based on those entitlements. And this goes against the whole concept of finality in delimitation judgments. And I think then the only practical option left is not to delimit the outer shelf. And so I think there were, of course, practical issues. I completely agree that the court was trying to avoid. Those mentioned, maybe some of them. I think this is also one of them. There's a lot then to say, but I know Sir Michael will also speak on about the case. So I'll quickly move to comment about Professor AKHAVAN's presentation. Now, Professor AKHAVAN and I were on a panel last week together, so I may be a little repetitive, and I apologize to him. I wanted to add, so Professor AKHAVAN rightly said that I think ICLS and ICJ had a very different approach to the obligations in the climate treaties, while ICLS saw them as mainly procedural. And then there were separate and different obligations under UNCLOS. The ICJ took this approach of what it called the entire corpus of international law, put it together, and found one substantive obligation. I wanted to add that there, I think, is also a third approach, which the ICJ quoted, and that's the approach of the Human Rights Committee. Whether in Te Tiota versus New Zealand, in the Torres Straits case, where climate treaty obligations and human rights obligations are separate regimes with distinct obligations, but they cross-pollinate and influence each other in a state's understanding of its obligation. So, as the Human Rights Committee says, a state must take into account its human rights obligations when fulfilling its climate treaty obligations, and the flip coin of that, when a state is fulfilling its human rights obligations, it must take into account the content of its climate change obligations. And so perhaps this is a third approach and a bit of a middle ground. The last thing I wanted to talk about very quickly is about the potential impact of the advisory opinions. And I think an interesting case that came out recently from the jurisprudence of the European Court of Human Rights in Greenpeace Nordic v. Norway shows both the contribution of the opinions and also their limitations. Here, the court quoted the advisory opinions, including that of the Inter-American Court, on the content of obligations of environmental impact assessments. And so it really helped in the context of procedural obligations. But then the court refrained completely from addressing Norway's substantive obligations under the climate change regime and avoided the question whether Norway could initiate new fossil fuel projects. And this shows, I think, also the limitations of the advisory opinions and how much they can contribute. And I completely agree with Payam that they can contribute to push states, but the political issues or the political proceedings are much more relevant to actually making a significant change. And then I'll just ask Payam one question, and this sort of piggybacks on Ximena's question. I know that the advisory proceedings were initiated, as Payam said, because of the frustration of small island states with lack of progress in the COP and the political process. And so I'm wondering, despite all of the difficulties with contentious cases, what will it take or not take, or what won't happen that will make states think that it's worthwhile now to initiate contentious cases? Thank you.
Thank you very much. So as promised, we have a little time. I will give the floor to Sir Michael Wood if he wishes to rebut the arguments. Sir Michael, you have the floor.
Thank you very much. I didn't really want the floor. I've nothing to add to what Eran STHOEGER has said about the Nicaragua-Colombia case. Obviously, I think it was a good decision. I think it was a sound decision. I think it's good law. I feel no need to discuss the matter with various bloggers and others who question it. But having said that, of course, I agree with Eran. There's no such thing as a binding precedent in international law, so anyone is free to argue that it was wrong and that The ICJ itself or other courts should take a different view. I wish them luck. I think that, however, the ICJ has made it clear that it will only depart from its previous case law where there are strong reasons for doing so. And I think also other courts should only depart from the case law of other courts, as it were, of the ICJ, if they think there are strong reasons for doing so. So I think, although there's no such thing as a precedent, there is an importance to be attached to consistency in international law. I'll just make that point. Thank you.
Thank you very much. And before I give the floor to the audience for questions, I wonder whether the three speakers would like to respond to comments from the panelists. Anyone?
Yeah.
Yes, okay.
Yeah, I'll try to be brief.
Briefly, of course.
Yeah, briefly. So I'll skip over the first point that Dr. HINRICHS made about the observation of Judge OUDE, but maybe just the question she directed to me directly on paragraph 274 of the judgment in Mauritius, Maldives. I would say it talks to a different point, I would say. I think the court there, the tribunal, the special chamber, I should say, determined a boundary within 200 nautical miles that was within 200 nautical miles of both states. And then obviously you don't create a gray area. I don't think they, in this sense, they were saying that you can never create a gray area, but I think the specific approach of the special chamber in this case led to the absence of a gray area. By the way, what is interesting maybe in this case is that if you look at paragraph 274, at the last sentence it says that there is a claim of Maldives to a continental shelf beyond 200 nautical miles within 200 nautical miles of Mauritius. It's not exactly phrased in that way, but that's what it's saying. So the Maldives is another example of a state that considers that it's possible to have a continental shelf beyond 200 nautical miles within 200 nautical miles of another state. And I think, and in that sense, I would also disagree with the observation that there are very few states that have taken this position. I think it's quite a significant number of states and also very significant maritime states. I think the interest of the decision in Mauritius Maldives maybe is at another point, and I think that's particular in the discussion of the delimitation of the continental shelf beyond 200 nautical miles, which was done subsequently after the delimitation within 200 nautical miles. And without going into much detail, I think if you look at paragraph 441, I think that raises certain questions about the happy to elaborate at another point, but I would say for people to reflect on that seems to raise certain questions about the consistency of the case law of the ICLS itself in Bay of Bengal cases and the special chamber in Mauritius, Myanmar. Because in my view, this says something different from what the court did in Bangladesh, Myanmar. But for the moment, I'll leave it at that. Let's see if there's anything else to... yeah, just one other point I wanted to point out. In the presentation of Dr. LIAO, there was a reference to cases that have dealt with the delimitation beyond 200 nautical miles. And what I noted that was the case between Guinea and Guinea-Bissau was not indicated as a case that dealt with the delimitation of the continental shelf beyond 200 nautical miles. I think it did, because the court, the tribunal in that case, determined an all-purpose maritime boundary extending delimiting all of the jurisdiction of the states concerned. And if you look at the subsequent practice of these states, they both have made, or they have made a joint continental shelf submission, which is also located in the area of the maritime boundary. So that's also interesting in this case that, by the way, created a gray area of about 8,000 square kilometers, so not that insignificant. Maybe a final point, gray areas as a consequence of delimitation. I would say that if there cannot be any overlap between maritime entitlements, you cannot delimit them. So I don't see how that's possible. I didn't hear an answer to that, I must say. Thank you.
Thank you. Anyone else?
Yeah.
Yeah. Yes. Just briefly, of course.
Just quickly to Dr. HINRICHS. very interesting question now. What happens if a tribunal disagrees? What can it do and what are the tools available? I think in the context of maritime delimitation, I mean, the kind of trite response is, well, if you look hard enough, you can probably find an authority which might support your kind of difference of opinion. But I guess the other point is that, at least in terms of maritime delimitation, I mean, both ICLS and the International Court have kind of agreed to the three-stage methodology, but then they've kind of departed from that in terms of its application. So, for example, in the Black Sea case, you know, the starting point was deemed to be the kind of equidistance median line, but immediately the court disregarded, for example, the base points around Serpent's Island. In the Bangladesh-Myanmar, I think, again, it agreed that, you know, we'd use the equidistance line, but then kind of proceeded to use the azimuth method. So they kind of claim they're doing one thing, but will, in the kind of detail, try and do different things. And I guess that the point would be that the law on maritime delimitation, it seems to have sufficient flexibility built into it, so they'll probably look to kind of exploit that. And if it comes to quite a hard decision where there seems to be a very strong divergence, I guess the point would be that they would just provide reasons for this, although I'm not sure what those would be. Coming to Professor Bowe's point about the climate case and the court's use of the ILC's opinions, I think just the kind of broad response there is that the court was quite conservative about trying to kind of state exactly what the kind of specific forms of liability would be, because I think it said that it couldn't assess these in the abstract, so what it kind of preferred to do was kind of outline the various options without pinning it down to any particular outcome. So, and then just to come back to Eran's question about fragmentation. Yeah, I don't think fragmentation is bad in itself, but you highlighted the third case there, and I guess the point was that the court provided reasons why it disagreed with the third committee. You know, so it made the distinction there between birth and nationality as the basis of its decision. So there's always scope there to kind of use reasons. And I think it's that the emphasis is on, as long as there are, I guess, plausible reasons, then that's the way things will proceed.
Thank you. Payam?
Just briefly, one interesting dimension of harmonization arises in the climate change advisory opinions insofar as there was a sequencing whereby the ICLS opinion was delivered in time for the states participating in the second round written pleadings of the ICJ process to incorporate that new jurisprudence in their submissions. And I can say now that it's all behind us that it was a very deliberate decision on the part of the small island states to do that. And it's a matter of speculation, perhaps a topic for a great PhD dissertation, to look at whether and how the ICJ would have written a different opinion had the ICLS opinion not already been delivered. But I would say one thing, getting back to the question regarding paragraph 245 of the ICJ opinion, importing into the NDC substantive obligations. The point is not the result, but it is the methodology which has been adopted. It would be correct to say that under customary international law, principle of transboundary harm, or under UNCLOS, there is an obligation to stay, to exercise due diligence, to stay within the 1.5 degree temperature goal. But in my view, I think the mistake of the ICJ is to import that obligation intrinsically under the Paris Agreement, not by reference to wider obligations under international law. And while, as jurists, we may celebrate progressive, so-called progressive jurisprudence, there is a danger when states did not sign up under the Paris Agreement to binding substantive obligations, in addition to imputing in declarations that are made in the COP process some legally binding quality. There is a danger in creating a chilling effect whereby states are going to be that much more reluctant to make any commitments in the COP process. So that is why, on balance, I think I prefer the ICLS approach, which is more cautious, less ambitious, but which in effect achieves the same result.
Thank you very much. We have 10 minutes and 50 seconds. I'm reminded by the organizers that we have to finish at 12:40, otherwise no lunch will be served. So the first have here President Haida, and too many of you, just President Haida first. Thank you.
Thank you. Thank you very much. Thank you for really an excellent panel. It's really quite excellent. I just want to make two brief comments. The first one, unsurprisingly, on the Nicaragua-Colombia case. So I think the fundamental question here is really, and this is my personal remark, the tribunal, as I said, has not addressed this million-dollar question, as I call it, from Nicaragua-Colombia in a general manner. So the fundamental question is whether there is any hierarchy between continental shelf based on natural prolongation and on distance in Article 76, paragraph 1. And I think, personally, the plain reading of this provision does not suggest that there is any such hierarchy between the two. When it comes to then the relationship between the EEZ and the continental shelf, I think it is important to look at the history of the law of the sea and to recognize that the continental shelf is the older regime. It was there already when the Law of the Sea Convention was adopted, which introduced the EEZ, which was superimposed on the already existing continental shelf. So even though there is some inconsistent language in paragraph 56 and in the convention, I think it is healthy to regard these two regimes as distinct regimes. There are two different parts for these regimes, part 5 and part 6. But I wanted to highlight one aspect. That's the reason why I comment on this case now. And it is that, I think the ICJ should have proceeded to delimitation in this case. But then it would have been for Nicaragua to demonstrate that it has natural prolongation beyond 200 nautical miles. This is what ICLS would be using the standard of significant uncertainty in this exercise. And even if Nicaragua had succeeded in demonstrating the entitlement beyond 200 nautical miles and within the 200 miles of Colombia, that doesn't necessarily mean that even if there is entitlement, it doesn't mean that they will have a shelf eventually within the 200 miles of Colombia. And why is that? And this is where I want to refer to, I think, a very useful dissenting opinion of Judge Charlesworth in this case, because she emphasizes that if the court goes into the delimitation, then of course the goal of the delimitation is prescribed in Article 83 as being one of to find an equitable solution. And I think, I think this issue is not as black and white as one may think, because I think in most cases probably, based on equity, the Colombias of the world, the country that is seeking a 200-mile continental shelf only, will have that 200-mile continental shelf, simply based on equity. There are instances, and the Bay of Bengal cases are the perfect examples, where this will not be the case, because it was impossible in the Bay of Bengal cases to achieve an equitable solution without allowing Bangladesh to have extended continental shelf within the 200-mile zones of Myanmar in the ICLS case and of India in the Arbitral Tribunal case. So I think this issue is not as black and white as one may think. I think if you think practically, this may be a healthy solution to allow simply the equitable solution goal of Article 83 to take care of these issues. The other comment I wanted to make is that I thought Professor Barnes made very interesting discussion about judicial dialogue, and I just want to offer an example of what I think is the most direct form of judicial dialogue, and it is when meetings take place between these judicial bodies. And so just to add that we recently had a meeting in The Hague between a delegation of ITLOS and the ICJ, and I will not reveal anything about what we discussed, but you can only imagine. Thank you very much.
Thank you. President Haida, I think we have only 5 minutes, so I have to draw a lot. So I choose the lady in the middle, wearing glass. Yes.
Yes, Judge, thank you. So, hi, good afternoon. Thank you to the panelists for a really perfect discussion on maritime dispute settlement. I am Chloe May de Guzman, representing the Philippine International Law of the Sea Academy in alignment with Konrad Adenauer Stiftung Rule of Law Program Asia. And I would actually like to direct my question to Professor Barnes regarding judicial dialogue. And my question is regarding the compulsory jurisdiction. So while there is compulsory jurisdiction in cases of environmental protection, it is quite evident from the optional exceptions that the issue on boundaries, the limitations, and sovereignty are set apart from the issue on environmental protection, especially in environmental cases where time is of the essence, as in climate change. States have an interest in resolving this at the earliest time possible. While it is not always the case, how could a coastal state in conflict with boundaries efficiently come into judicial dialogue with another state on environmental protection when boundaries, the limitation, or sovereignty over the area of interest is an incidental question to the environmental protection issue? Thank you.
Thank you. You have very... now you have to... Anyone want to answer? You have to finish at 12:40.
Oh, gosh. Thank you, Judge Haida, for the piece of advice, which I look forward to trying to wrangle out of you over lunch about what was said. I probably want to talk to you about the kind of question about environmental protection, but it strikes me as kind of a difficult one there, because going to court to litigate to protect the environment is probably not always the quickest and easiest way to do that. So I'm not quite sure how judicial dialogue would kind of work in the kind of context there. So perhaps you can talk over lunch on that one.
Thank you. If you have a question.
Hello, thank you for giving me the mic. My name is Yeon Hee-jung. I'm from Mufa, Korea, and I'm also a student studying international law in graduate school. So my question is about the Nicaragua-Colombia case, and I want to say that I totally agree with Professor ELFERINK and Dr. LIAO, and thank you for their strong and convincing presentation in this matter. And I think, and I hope and believe that this Nicaragua-Colombia case should and could not be the final word in this matter. And I also think that there's the EEZ regime and the continental shelf regime are two interrelated but definitely separated regimes. And my question, and I'll go to my question.
Your question is too long.
Sorry. Sorry. So, if the my question is, like, if the Nicaragua was allowed to have the entitlement over 200 nautical miles of its coastline, then how the court or how the other tribunal could have the delimited the boundary between boundary of their outer continental shelf from between Nicaragua and Colombia? Thank you.
Okay, you have one minute to answer. Anyone?
Well, I would refer you to the pleadings to the extent they are online. Thank you.
Okay, thank you so much. I think we have to finish really. Otherwise, everything will be shut down. I'm warned many times by that charming lady there. Okay, thank you very much. Please give applause to our speakers and panelists for this.